Hello friends, welcome to this video on Gap Advisors channel. Myself CM Anish C. Iyer. The research committee of the Institute of Chartered Accountants of India has issued an exposure draft of capital transfer of capital reserve with the last date of comment being 20th April 2023. The exposure draft seeks to provide a principle on when can the amounts recognized in capital reserve be transferred to retained earnings. Capital reserve is a component of equity. IFRS does contain requirements on transfer from one component of equity to another, such as the transfer of FVOCI reserve on equity investments designated at fair value through other comprehensive income. However, the exposure draft states that IFRS is silent on transfer within components of equity. IFRS may not say fully on transfer of each component of equity. However, it does require some it does contain requirements for some of the components. However, IFRS does not state anything on capital reserve as such. The basic reason for IFRS not dealing with the timing and extent of transfer between components of equity is because this is a legal matter and depends on the law of the land. A reserve that is distributable in one jurisdiction may not be distributable in another jurisdiction. The requirements related to recognition in capital reserve is contained in Ind AS as carve-out from IFRS. Capital reserves are also created by provisions of Indian Companies Act 2013 and utilization of the same are governed by requirements of that law. Therefore, the research committee has stepped into the shoes of Ministry of Corporate Affairs to clarify when and how the amount recognized in capital reserve should be transferred to another component of equity that is distributable. It may be noted that Companies Act 2013 specifies what are free reserves and accordingly clarifies when and to what extent an amount can be transferred to a component of equity that is available for distribution. However, the exposure draft, in my view, goes beyond the purview of research committee. Further, the title of the exposure draft is confusing. There is never a transfer of capital reserve. There is a transfer from capital reserve. The transfer from capital reserve is of amounts recognized in that reserve. The exposure draft firstly identifies the sources of emergence of capital reserve as under 1. Business combination. Para 34, 36A of Ind AS 103 and para 12 of Appendix C of Ind AS 103. 2. Investments in associates and joint ventures, para 32 of Ind AS 28. 3. Interest-free loan from parent to subsidiary. I do not agree to this interest-free loan from parent to subsidiary. In that case, no capital reserve is created. Ind AS does not contain any such requirement. The practice of recognizing loss on interest-free loan as an equity item is open to debate, and the company should have done proper research on this topic itself before proposing the same in an exposure draft. For example, it could have researched as to when an interest free loan or whether an interest free loan is basically an investment in the capacity of owner or in the capacity of investor, because even lenders waive interest on loans. So if a shareholder gives a loan to a company and waives that interest, is that in the capacity of owner or lender? Because the owner is asking money back, whatever he is giving. There is no discretion here for the entity that is borrowing the money. So if there is no discretion for the borrowing entity, then it's not an equity as such, but the exposure draft simply says everything is a capital reserve, which is not proper. Then it says capital reserve arises in equity settled share based payments. I again do not agree to this. In case of equity settled share based payments, the reserve recognized as ESOP reserve, employee share based options reserve, that is ESOP reserve, and not capital reserve. Capital, then it says capital reserve recognized as per Indian GAAP. Okay, capital reserves are recognized as per Indian GAAP and not adjusted in Ind AS. I once again do not agree to this, as para 10 of Ind AS 1 does not permit any reserve recognized in Indian GAAP to continue in Ind AS unless permitted by Ind AS or by Appendix B to D of Ind AS 101. 6. The source is provisions of Companies Act 2030. Thus, the research committee has failed to do research, proper research on the sources of capital reserve. The research committee then proposes the following: any reserve created as per requirements of the law shall be transferred as per the requirements of the law. Okay, so but I do not understand the necessity for exposure draft to be issued for this. This was very much clear, because no one can go beyond the law. The second, it says that the amount recognized in capital reserve created as by Ind AS can be transferred to retained earnings or other free reserves only when the company has realized the underlying amount and the amount has become available for distribution as per applicable laws. Here again, I do not understand the necessity for an exposure draft to be issued for this, because what are free reserves is clearly defined in Companies Act. So when anything becomes when any amount is available as a free reserve, then naturally one can always transfer from one reserve to another reserve that is distributable. So again, this is very clear in the law. What is the requirement for the research committee to spend time on this? What is the research being done on this? I am not very clear. It seems the research committee has no idea of what to research. There are already multiple versions of Ind AS floating around, and this exposure draft proposes one more version. The multiple versions of Ind AS floating around are: 1. Ind AS as notified by MCA. Second, Ind AS as amended by court schemes. Third, Ind AS as amended by MCA clarifications. In court schemes, for example, now the Schedule 3 itself recognizes that there can be a deviation in a court scheme from the applicable accounting standard. So, therefore, Ind AS as amended by court scheme is a second version of Ind AS. The third version is Ind AS as amended by MCA clarification, such as the clarification of appointed date. Fourth is Ind AS as amended by ITFGs issued by ICAI. Fifth is Ind AS as amended by EAC opinions issued by ICAI. And sixth is Ind AS as amended by guidance note on Schedule 3 issued by ICAI. This Ind AS will add to a new version of Ind AS, that is Ind AS 7.0. There are many areas where the research committee can contribute positively. This video has already become quite long, and therefore I will discuss those areas later in another video. For example, I can in brief I can just give you a hint that Ind AS 28 requires capital reserve to be recognized. Whereas IAS 28 says that bargain purchase should go to profit or loss. It should not be recognized in capital reserve. Still, Ind AS 28 does not identify this as a carve out. Why? Because it says that because Ind AS 103 requires capital reserve, so this is a consequential amendment to the standard, and this is not a new carve out. However, the impact of this creates a carve out. How? Because what happens is when you dispose an associate, when you dispose an associate, then all gains and you will de-recognize the investment in associate and recognize the consideration, and also you will reclassify all items of OCI to profit or loss, whichever is reclassifiable. Items that cannot be reclassified to profit or loss are not reclassified to profit or loss on disposal of associate. So under IFRS, what happens is the bargain purchase gain was already recognized in profit or loss, whereas in Ind AS it is recognized in capital reserve, an equity item. That equity item does not come to profit or loss. Under Ind AS 28. Same is there is a inconsistency between Ind AS 110 and Ind AS 103, business combinations and consolidated financial statements. Because of this carve out, in fact, it is also it also creates a conflict with the framework, conceptual framework for financial reporting issued by the Institute of Chartered Accountants of India. So these are some of the areas where a research committee can really do a wonderful job and do a great research work and come out with some very good principles and provide guidance on the necessity of these carve outs and whether these sort of inconsistencies are actually required or can be removed. I hope you found this video useful. Thank you.